Our presentation is about law and network technology. The increased importance of networks has brought about various challenges with regards to legislation. Network technology poses a challenge for existing legislation due to various reasons, such as its intangibility, lack of borders, non-existence of international regulations, absence of legislation, and its integrated characteristics in absence of taking its integrated characteristics into account, the need to define and redefine basic terms that are dated, the fact that new legislation usually relies on partial adaptations of existing laws, as well as the fact that existing legislation was developed in past phases of economic development. Nevertheless, legislation is essential when it comes to preventing and sanctioning the misuse of network technology. Law in relation to network technology is a very broad topic. Therefore, we have decided to focus on two issues, namely freedom of communication and intellectual property. The first part of our presentation focuses on intellectual property, while the second part of our presentation focuses on freedom of communication.
Intellectual property refers to creations of the mind, such as inventions, artistic works, designs, names, and images used in commerce. It is protected by law by, for example, patents, copyright, and trademarks, which enable people to earn recognition for financial benefit from what they invent or create. By striking the right balance between the interests of innovators and the wider public interest, the intellectual property aims to foster an environment in which creativity and innovation can flourish. The different types of intellectual property are copyrights, patents, trademarks, industrial design, and geographical indications. The internet does not know any national borders, so website content can be viewed from anywhere in the world. This raises the question of what court has jurisdiction when the content of a website infringes on intellectual property rights. Within the EU, this is answered on basis of the Council regulation. The regulation has established the principle that a person must be sued in the court of a member state where the person is located. This would mean regarding infringements on a website that any court action would have to be filed with the court of the member state of the responsible person. The exception is Article 5 of the regulation, which refers to delicts concerning infringements of contents placed on the internet websites. Article 5 says that a person domiciled in a member state may be sued in the court of the place where the harmful event occurred or may occur. Where this place is can only be answered with regard to the nature of the affected intellectual property rights. The European Court of Justice specified this with personality rights, trademark rights, and copyright.
Now we will address a case study, namely the one of Napster. In one of the Internet's most well-known intellectual property cases, the Recording Industry Association of America sued Napster, a file-sharing company or a file-sharing site. Founded in 1999, Napster allowed users to share music files, and thousands of people began downloading songs for free rather than buying CDs. However, Napster did not own the rights to the music that people were uploading to its servers, where the music was stored and ultimately shared. The rights were owned by the recording artists and the recording studios. The Recording Industry Association of America sued Napster and won, causing Napster to close its borders and its doors, and more specifically its servers. Napster now operates as a fee-based music download site and pays licensing fees for the music it sells. This case represents a landmark in the uncharted waters of internet copyright law, with policymakers and lawyers watching closely. Legal experts have also said the implications for the case extend beyond music to the sharing of other media like movies, and may set the tone for how intellectual property law is defined on the internet. The legal battle over Napster began in December when a number of record companies represented by the Recording Industry Association of America sued Napster for copyright infringement. The Recording Association asserts Napster is guilty of contributory copyright infringement. The industry contends that Napster has built a business by encouraging individual users to share music files they do not own. But Napster claims that the online trading of MP3 music files falls within the parameters of the 1992 Audio Home Recording Act, which permits copying music for personal use. This is not the case because Napster allows repeated and exploitative copying, which ultimately harmed album sales.
And now I'm going to talk about information and communication freedom. So everyone who lives in a democratic country has rights to information and communication freedom, or in other words, freedom of speech, which means that an individual has a freedom of expressing ideas and opinions without government censorship. When it comes to information, people also have the freedom to receive it. But in practice, these freedoms are not always realized and are quite contradicting. For example, there is no guarantee that certain information will reach you, since regulatory bodies and service providers decide on which channels can be received. In general, these laws mainly protect from government censorship and interference. However, this does not involve protection from private intrusions. Thus, these problems are usually covered by other laws, such as privacy laws. Another important point is the fact that this freedom is not absolute. It ends where it concerns privacy, security, identity, and personal interest of other individuals, and where it concerns national security, sovereignty, cultural identity, or economic interest of a state. Because of that, many conflicts arise in this area, and most of the times they can never be solved completely, since it is quite hard to do so. International legislation is too general and sanctions are too weak. It is also hard to implement any national legislation since there are no boundaries in cross-border networks. Also, there are a lot of areas which suffer because of lack of legislation on the new media channels. This legal aspect of networks can be used to avoid national legislation, which enables criminals to avoid taxes, privacy legislation, or rights of ownership. For example, data can be gathered in one country and distributed in another where regulations and sanctions are not as harsh. Another important aspect is that passing on confidential data could potentially cause a threat to national safety. Thus, many countries have agencies that control networks that contain sensitive information. Lastly, underdeveloped or developing countries feel threatened by these new media channels, especially the internet with its huge databases. Because it is so hard to control all information and content on these networks, including the behavior of its users, some governments say that it threatens the freedom and safety of the society as a whole.
Laws are always made after certain incidents happen. As the book The Network Society suggested, the law and justice have lagged behind new technology in almost every period in history, as new technology must become established in society before legislation can be applied to it. Furthermore, the consequences of new technology are not always clear right away. Regarding legal practices in this digital and internet age, it is important to discuss the term of surveillance. This case study is about the NSA 2001 to 2007 warrantless surveillance program. This program concerns surveillance of persons within the United States during the collection of allegedly foreign intelligence by the United States National Security Agency as part of the War on Terror. It is a result of the Patriot Act that is passed by the United States Congress after the attacks of 9/11. This act granted the president at the time, George W. Bush, broad powers to fight a war against terrorism. The Bush administration then used these powers to bypass the Foreign Intelligence Surveillance Act and directed the NSA to spy directly on Al-Qaeda. But reports at the time indicated that an accidental glitch resulted in the interception of communications that were purely domestic in nature. Under this program, which is referred as the Terrorist Surveillance Program by the Bush administration, the National Security Agency was authorized by executive order to monitor, without search warrants, the phone calls, internet activities including web searches and emails text messages, and other communication involving any party believed by the NSA to be outside of the United States. It has been discovered that all United States communications have been digitally cloned by the governmental agencies in apparent violation of unreasonable search and seizure.
To conclude, laws are important when it comes to preventing and sanctioning the misuse of network technology. Yet there are various reasons why it is difficult to implement legislation for network technology. People in democratic countries are in theory free to receive information. However, it is not always the case in practice. There are laws in force that protect people from government censorship. However, this does not include protection from private infractions. Furthermore, the freedom of communication is not unlimited. It does not include issues that affect the privacy and personal interest of individuals, as well as national security, sovereignty, cultural identity, and economic interests of a state. At times, the state can also use the fourth-mentioned reasons as an excuse to spy on its citizens, as was the case with the NSA. Additionally, the absence of comprehensive laws also make network technology attractive for criminals. Creations or inventions of the mind in the field of literary and artistic works, designs and symbols, names and images used in commerce are referred to as intellectual property. Intellectual property is protected by law in order to permit individuals to get recognition and financial benefit from what they've created. The case of peer-to-peer file-sharing service Napster was one of the most significant legal disputes when it comes to intellectual property on the internet. Napster was found guilty in the court of law of copyright infringement. Ladies and gentlemen, thank you for paying attention to our presentation.